I'm Michael Wild, and this is your estate planning tip of the week. So for this week's estate planning tip, I've got a prop, and it's a 12-year-old bottle of Macallan Scotch. Why am I holding a 12-year-old bottle of Macallan Scotch during the estate planning tip of the week? Well, besides the fact that I'm recording this at 5 o'clock on a weekday, which is usually when we break out the Macallan, I want to point out that this particular bottle of Macallan has been aged 12 years. When your child is aged only 12 years, then it is important that your will appoint a guardian for that child. It is a misconception that just because you have living parents or living brothers or sisters, that those people would have the right to raise your child automatically. No, you must appoint a guardian by way of your will to let the court know exactly who it is you've designated as that guardian. It is not automatic. It is not statutory. It is done by document. Now, today I only brought the 12. The 15, the 18, the 21, and the 25 are all at home, not at the office. So we're going to have to use our imagination when we talk about that. But as the children grow older, when they're 18, they may be financially and emotionally dependent on their parents, but they are adults at that point. They need their own documents, their own healthcare surrogate, their own power of attorney, their own living will and HIPAA release. Otherwise, their parents won't have any access to any of their medical information. When they reach 21, well, maybe they're adults, they've graduated college, but maybe they're not ready to manage their own money. It's important to have a trust in place that stipulates when and how any assets you leave behind can be managed. They hit 25, maybe you say, okay, 25, that's old enough, let them manage their own trust. Great, but they still might need that protection from divorce, creditors, litigation, bankruptcy, all the things that a trust offers. So whether your baby is 12, 15, 18, 21, 25, or even older if you can afford it, make sure you have the proper documents in place, a will, a trust, a power of attorney, a healthcare surrogate. Make sure everything's prepared so you can protect the things that you care about. I mean, the children that you care about the most. My name's Michael Wild, and that's been your estate planning tip of the week.